Hi, everybody. This is Arkady Frekhtman. I'm a New York City personal injury trial attorney. And today we are answering your questions and talking about your comments on this episode of Last Week Tonight. Jazzy asks, can a New York City lawyer represent someone from another state? Yeah, so the way that works is they can't represent you only, if they're only admitted in New York and you're in another state, let's say Pennsylvania, and they're not admitted in Pennsylvania, they cannot represent you alone. But what they can do is a New York lawyer, like myself, for example, I could partner with a local lawyer, like a Pennsylvania lawyer, Florida lawyer, California, anywhere, right? Even like Hawaii or Oregon or Texas. And then that lawyer will have primary responsibility because they're local counsel, they're there, they're handling the case, and I'm kind of working alongside them. So I could be involved in the case as much as you'd like. I could also speak with them. I could also speak with the client and keep the client informed about what's going on. And then if the case were to go to trial with a jury, if the client wanted that, and if the lawyer agreed to that, I could come down and do the trial with that lawyer and work on it together as a partnership. So I've done that before, and I'm happy to do that for the right case. And then the other question is, do you have a video based on bad faith? Do you have a video on insurance companies not making any offers after a demand? Yes, I do. I've had a few videos about bad faith. I'd have to go back and find them and then maybe put a link in the comment for the specific videos. But I've talked a lot about bad faith and opening up policies. And the way you would do it is if you send a letter and you say, look, you have a limited policy, for example, you only have 50,000. So look, my injuries are worth way more than that. My injuries are worth 500,000 or more. But since you only have 50, I'm willing to take the 50. Just pay me the 50. You have 30 days. Here's all the evidence. Here are my medical records. Here's my photographs, your witnesses, or whatever you have, authorizations to get the medical records directly from the various doctors. And then if they don't pay, then you can make an argument that they're not negotiating the case in good faith, and they're also not defending their policyholder because they have to look at the policyholder's interests on an equal footing with their own interests, right? So you have the policyholder who bought this insurance, and you have the insurance company. The insurance company is holding all the money. They want to save their money. They don't want to pay, but they have to protect this policyholder because if they don't pay, the verdict could be like $5 million, right? And then the policyholder only has a $50,000 policy. They're going to be left out to dry. Who's going to pay? Who's going to pay that? They're going to pay that themselves. They can go bankrupt. They could lose their house. That's the whole reason they bought the insurance from the insurance company, right? For protection. So there's ways to open up policies, and the law will vary depending on the state you're in, but it can be opened up. And then, so that's the idea of bad faith. Here's a comment. Someone says, absolutely make them pay in response to my video, insurance companies lowball and why it doesn't matter. Right, because if they lowball, it doesn't really matter. You just have to know what the case is worth and know that you can get it from a jury and just prep the case that way. And I feel like if you prep the case for trial in the right way with your experts, including all the elements of damages like future medical costs, lost wages, which are economic damages, as well as non-economic, which are the human damages like the pain and suffering, the loss of enjoyment of life. You put all that together, you're prepared for trial properly. It doesn't matter that they're lowballing you because you could just go to court and you can get the fair number from a jury. And if they see that you are preparing the case properly, you have an economist, you have the doctors lined up, you have everything, you dotted your I's, crossed your T's, you're ready to go to trial. Well, guess what? They're gonna, they're billion-dollar companies. They understand risk, and they're gonna offer you more money as you pick a jury, as you start trial. And if they don't, then you have to take a verdict. And of course, when you take a verdict, there is risk. You could get a defense verdict, you could get less than you asked for. But if you prepare it the right way, it's unlikely. And what is very, very likely is that their offer, the lowball offer, is going to start to come up and up and up and up. So the best way to get them to pay is not to just call them. Some lawyers say, oh, I want to be aggressive, I'm the bulldog or whatever. It doesn't matter. What do you think? They're going to pay you millions because you scream at them or because you bark at them over the phone? No. What you want to do is you want to be professional and you want to prepare the case the right way for a jury trial. So you could get the money from a jury. And if they see that you're going to the jury, you're not afraid and you're fearless and you're going for that jury verdict, then they're going to pay you more money as a settlement. And I've seen that like time and time and time again. I've even seen it so many times with viewers. Like I've had clients who were YouTube viewers who came to me. For example, one case, there was already an offer, but it was low, a few $100,000, came over. We weren't afraid. We found out there was like an excess policy for like 25 million. We went into court, and this was just an aggravation of a pre-existing condition. So it wasn't even a new injury, but we were able to settle it for like 1.2 million. Another case where somebody had like a small offer, like I think it was 190,000, completely changed the landscape of the case, did everything, prepared it, went into court, picking a jury, settled for 2.2. A lot of times you could see it. Another case, very nice lady, she had a small offer. I don't even know if she had an offer, but yeah, it was like nothing was happening and they were afraid because it was in a tougher venue. It was like in Westchester. Prepared it, went into court, picked a jury, settled that for close to 600,000. It just depends. Like a lot of the times what I'm seeing when people come to me like fresh, that's always the best, right? Because I could prepare the case from day one and prepare it the right way. When people come to me from other attorneys, I see that sometimes, the cases are prepared well, but sometimes very often they're not. And then a lot of work needs to be done. And the case was on a path to like, either a defense verdict or like that small offer, like a few $100,000 at most. Whereas we put it on a path to like millions of dollars and we like 10x or more than 10x the prior numbers. So it could be done. It just has to be done the right way. Here's a question. Congratulations on 10K. Hey, if someone was on the trial calendar, but the trial never happened, then the case would be disposed of or moved to another court. How long would it take to get back on the trial calendar? Yeah, so that's going to vary depending on where you are. I'm sure the time limits will, vary based on your city. In New York, usually you can get back on the trial calendar even in a day, as long as everybody stipulates to it. So you have to sign a stipulation. Now, if the defendants, for whatever reason, don't agree to sign the stipulation, you have to make a motion. So that'll probably take about a month or two for the judge to decide, maybe even a few weeks. It really is a simple thing, and then once you're back on the calendar, you might have to wait a few months. You would be back, where you were before. So depending on how far you were along before, they probably put you back in line. I don't know. I don't think they put you back at the very beginning. So you have to wait again the same amount of time, but they'll put you back and you'll probably have to wait at least a few more months until they give you the trial. That'll also vary on where you are, how many cases are ahead of you. So it can't really answer that, one answer for everyone. But from what I've seen when that happens, is usually not too much longer. Here's a question. Arkady, thank you for all your support and guidance. Is there anything we can do for you? Thumbs up, happy holidays. Yeah, just keep, interacting, keep chatting and liking and subscribing to our channel. It's really helpful. And also please, text me if you have a need for a consultation. I'm happy to help. And also, sometimes when we do the lives, come on live. I like that. Like last time we were live, I think we had close to 80 people at one time, which is, I think, the most we've had. So that's great that people are interested in this. People are asking questions and interacting with us. So we love that. Thank you so much. Here's a question from Merle. Does the insurance company like to go to court or settle before the end of the year? Tax time. Does it matter? So to appeal a lawsuit is 9% interest per year. Okay, yeah, so the first question, they do. There's something known as, we call it like settlement season, right? Anywhere from September to the end of December. And it's kind of like a time when more cases settle. I wouldn't say that all, again, it's not like categorically, right? Like every case is going to be distinct. Some cases, of course, do go to trial. There are trials in November and December, so they don't settle. But for the most part, we've seen that insurance companies are more likely to offer money and settle towards the end of the year, maybe write the case off their books or use it as a tax deduction. So yeah, that is true. And then with respect to an appeal, I'm not sure what you mean. I think they're responding to a live I did. I think in that live I was talking about summary judgment. So if you file a motion for summary judgment in New York as a plaintiff, for example, if you're rear-ended by a car and that motion is granted, you can then get 9% interest from the date that that motion is granted up until the time of the trial. So for example, I have a case that just happened in November of 2024, but it's a clear case. My client stopped at a red light, truck rear ends him. I could file a motion now, just include the police report, include an affidavit. He was rear-ended, he was stopped. What's the issue of fact? What's the question as to liability? There is none, right? So I get a judgment. Judgment comes down, let's say in December of 2024, but then the case doesn't go to trial until December of 2026, right? 2 years later. But I get $1 million, let's say, for damages. Well, now I have $1 million plus 9% for those 2 years, which is like $180,000 more. But because I have that hanging over the insurance company, they don't want to pay close to $200,000 more. So they are more likely to settle the case instead of waiting all the way to those 2 years. With appeals, I believe there's also interest on appeals. That might be a little bit different. And then Frankie says, how long does it take for a lawyer to know about the insurance policy limit? Does it take time? What about 3 or 4 companies are involved in the accident? Can they be together liable? Thank you. Best lawyer in New York City. Oh, thank you so much. Yeah, so it depends on which state you're in. So in New York, we have a rule that you could actually find out as a claim when you're pre-litigation, right? You could send a letter of representation saying, hello, my name is Arkady, I'm a lawyer, I represent John Smith. And in that letter, you can put, pursuant to insurance law, I believe it's like 4520F. I don't know why I remember that, but you put it right in the letter and you say, provide me with the insurance limits. And they're gonna tell you, okay, we have 100,000 policy. But remember, they're only telling you the primary limits. They're not gonna tell you the excess or the umbrella. So once you file a lawsuit, there's the CPLR sections where they have to tell you all the insurance, and it's in the preliminary conference order. They're supposed to do it automatically, but sometimes you do have to ask for it or you have to fight with them a little bit. But you're gonna get it eventually. And then they're gonna tell you the primary, like for example, we have 250 primary, but we have like 3 million excess or whatever it is. So that's always good to know. And then Mr. Carter says, hi, after the release is signed, is it a certain time frame for the insurance company that has to send the check to the attorney? The case is in Pennsylvania. Yeah, well, I'm not sure about Pennsylvania, but usually it's about 30 days that they have to serve it in New York from when you provide all the closing documents. So duly executed releases, hold harmless, stip of discontinuance, all the closing documents, as long as they're duly executed and everything is in them, then they have about 30 days. And if they don't send you the check, right, if they don't pay the settlement, then you could enforce the judgment. You could make a motion. And then Merzuga says, hi, Arkady, thanks for the awesome video, and we learn a lot from them. Being a bus operator and got into a wreck, not my fault, my back suffered a herniated disc that I had to get a discectomy surgery, but my foot constantly was in pain. Saw a surgeon for that and said that I have arthrofibrosis requiring surgery. Have you ever encountered a case with an arthrofibrosis? Thank you for all your help. Yeah, so no, I haven't had too many cases with that, but I'm happy to research it. And I believe arthrofibrosis is when you have an excess buildup of scar tissue. But I suppose an excess buildup of scar tissue could be traumatic as well, or it could be after a procedure like the surgery. Yeah, depending on where it is, because according to what I know, sometimes it's in the knees. It could also be in the ankle. But yeah, feel free for something like that, because it's very case specific. It's better to text me, 347-566-9595, and I'm happy to chat with you and answer your questions and give you a consult. And then Mike says, love the channel. What is your thought on using a personal injury attorney who commonly works as a defense attorney for the insurance companies? Thanks. Yeah, so I mean, honestly, I don't like that, because especially if he's still working for the insurance companies, because it's a completely different mindset, right? Completely different mentality. The insurance companies just want to push paper, do the work, leave at 5 p.m., and then they want to save their money. Whereas a plaintiff's attorney, if you're a real plaintiff's attorney, trial attorney, look, you have to be working all the time. And you might have to work at night, you might have to work on weekends, you might have to get up early, like 4 a.m. and do work. You have a trial coming up, you have to be ready, and you have to have this passion that you want to help the injury victim. A lot of even plaintiff's attorneys, I mean, some who maybe also work for the defense, but a lot of even plaintiff's attorneys just see their clients as a number. Okay, I have this client, John Smith, whatever, Joe Blow, I don't know anything about him, but I know he's got like a fusion, so it must be a big case, I'll make some money on it. Oh, they're giving me money, they're throwing 500,000 at me. Oh, how about a little more? How about 700? Okay, let me park it here, let me call him, and now I'm gonna push it all down his throat, take this 700, it's so much money, but it's not in the best interest of the client, because look, even though it is a lot of money, maybe that case could be worth 3 million or 5 million. And so you really have to have a passion for being a trial attorney, helping people, and getting to know the client and going to their home, understanding their biography, understanding their human story. Then you can turn these cases into something much, much more valuable. But the only way to really do that is by being like a plaintiff's lawyer and being passionate. So I think maybe I have a bias. I mean, there are some good, plaintiff's lawyers that were formerly defense lawyers. Maybe they started their career, they worked for the defense for a few years, but now they're only plaintiffs and they're like, gung-ho, diehard, like plaintiffs lawyers. I don't know any that are doing both that are actually getting good results. Here's a question. Can we negotiate with the lender at the end of the settlement? Let's say I took $70,000 in 3 years. If I win the case, I have to pay back $210,000. Can we negotiate this? What if I don't want to pay this high interest? Thank you for always answering the comments. Yeah, I mean, you can. Of course, you want to negotiate it. You want to have your lawyer negotiate it and get it down as low as possible. But a lot of it will depend on your contract. Like if you took 70, let's say, and now you owe 210. So yeah, they might negotiate a little bit down. It also depends on how much the case settles for, right? If the case settles for like a lot, like 5 million, when they're going to say, well, why should we negotiate? You got a good result because we took the risk with you, right? We gave you 70, but what if you got a defense verdict? We would eat the 70. We wouldn't go after you. Remember, it's not a loan that you ever have to pay back. It's just you're selling them a piece of the pie of your case. So if your case goes for 5 million and the lawyer's taking like 1.7 or whatever, but there's still like 3 million for you, why shouldn't we get our 200? Because, we took this risk and we gave you 70K. And it's in the contract, right? That's what you have to pay us. But if the case goes for less, if the case goes for like, I don't know, 500,000, well, now the lawyer is taking like close to 200. Let's say you're getting 300, but now you have to give 200 of your 300 away. Well, in that case, you could say, hey, look, you gave me only 70. Even if we double it, I'll pay you like 140, but like, don't make me pay 210 because then I'm only getting 100K. And it's like all my money's gone. I'm basically not getting anything as a client. So then I think you could be in a better position to negotiate that, right? And it also depends on your contract. Some of these companies, they don't even cap. So so if you took 70K, it could actually be like 140, then 210, then 3, then 4, then 5. You could end up paying 700K back, right? So you want to make sure at the beginning you sign a contract that's capped with a ceiling. A lot of companies will do it at 2 times principal, so like 140, sometimes 3 times, which this sounds like about 3 times, right? 70 times 3 is 210. So I would try to do that at the beginning as well. Dwayne says, hey, so I got in an accident where I was rear-ended by a van on the highway in New York City. The car was damaged real bad, no severe injuries though, back and neck pain. Insurance is offering $6,000 2 days after. Need help and advice. Yeah, I mean, feel free to text me. It really depends on how you feel. I mean, it's kind of hard to decide, right? Only 2 days later. You don't want to settle the case for $6,000. I mean, of course, it's something, it'll go to you, but then later you don't want to find out, hey, wait a minute, now I have this really bad back injury. Now I'm going to need injections. Now I'm going to need surgery. And by the way, that van that rear-ended me has $1 million in insurance. Well, now the case is over. I took $6K. Sure, it's something. But hey, this case could have been worth $600K, right? If I had a lawyer, if they would have worked it up, so it's hard to know like 2 days later, if you're having any kind of pain, any kind of symptoms, it's probably better to get checked out with a doctor and then speak to a personal injury lawyer. Question for you, sir. I had a work accident 1 year ago in Brooklyn, New York, building collapse, third-party lawsuit, full on their fault. So far, 5 epidural injections, 1 shoulder rotator cuff surgery, and lower back discectomy surgery. Still doing therapy, may need full future surgery, big damages for my past and future. I can't live a normal. It impacted me in many ways, including ringing in the ears nonstop. This happened after I went to a chiropractic for my back, but this accident changed my life a lot. How much should I settle this case? Yeah, I mean, it's best to text me, so we could speak about everything, right? A building collapse, depending on if it's a labor law, if you're working construction, or if you're just in the building and it collapsed, and also the injuries. It would also depend on where it is, right? The Bronx might be different from Brooklyn. But I'm happy to chat with you, do some research. If you tell me your name, I could actually look up the court's public filings, the case probably in the lawsuit, so I could look up and review it and then give you some feedback on that. And also, if you're curious, if you have an attorney, you're curious, hey, what are my attorney's results? Have they had any good verdicts or settlements? I could look that up and send that to you by email. So I'm happy to help, but it'd be hard for me to say, like, based on a YouTube comment, but if I had to guess, I would say it definitely could be worth over $500,000 if you have a discectomy and a shoulder surgery. So, and plus the epidural injection. So it could be worth a few $100,000. It possibly could be even into the millions, because if you have ringing in the ears, that shouldn't be happening. That could be something with like a post-concussive syndrome or or type of TBI. So probably get that checked out. And if it only happened a year ago, you could still get additional medical care, which would make the case much, much stronger. And then the same person says, what if you want to change the lawyer? Will he still get 32% of the settlement, or will you own him anything for the work he did, let's say for 2 years? The way it works is the legal fee is usually a third in New York, right? So if you settle a case for $1 million, the third will be $300,000. Now, if you have one lawyer, they just take the $300,000. If you have two, they share the $300,000. But the client's share is the $700,000. That doesn't change. Even if you have 10 lawyers, right? All 10 share the $300,000, because that's the lawyer's fee, the lawyer's or the attorney's fee, the legal piece of the pie. But the client's share, which is the lion's share, the big money, the $700,000, that goes to you. So it doesn't really change. So it doesn't really matter. I mean, if you change lawyers, it doesn't really affect you as a client. What you want to do is hire the best possible lawyer that's going to get you the best possible result. Now, the other thing you have to consider is that if you're changing lawyers, it's better to do it when you first, as a claim before the lawyer even filed a lawsuit. Because once they file the lawsuit, then the new lawyer, it may be harder for the new lawyer to step into the case, because now the old lawyer has done a lot of work, right? Especially if they've already done depositions. Well, now the other lawyer is going to say, well, I did the lawsuit, I did depositions, and they're going to have a big chunk of that 300. So then it's financially not feasible for the new lawyer to step in, because he might have to do a lot of more work, like hiring experts, changing everything, especially if the first lawyer messed up the case, changing everything. But then at the end, they're going to get like a little bit of money, and then the first lawyer is going to get a big one. So it's not going to make sense for the lawyer to step in. So if you're going to do it, I mean, best to like hire the right lawyer right from the beginning, because changing lawyers is like not really recommended. But if you're going to do it, I would say before depositions is the best time, or before the lawsuit is filed, because the way the courts divide the legal fees is based on the proportionate share of the work, and also who got the result. Those are like the big factors they look at. And someone says, unfortunately, not everyone has the money to hire a lawyer. The goal of the insurance company is to save as much money as they can and pay out as little as they can. It is the goal of the adjuster to make that happen. Most of the time, they get away with it. Yeah, I mean, unfortunately, it's true. But remember, you don't have to have any money to hire a lawyer, because these cases are handled on contingency. So meaning, if we win money for you, then we take like 1/3, right? We win $1 million, we take 300, you get 700. So that's why it's on contingency, a percentage of the win. And if we don't win, we get nothing. So we risk our own money, we risk our own time, we risk everything, right? Because, for example, like the case that I was on last year, we ended up doing well. We ended up getting 3.5 million. But imagine we went all the way and we lost. I had like 100,000 in expenses on that case. I would just lose 100,000, plus you lose all the prep time, which was, I don't know how many hours. We actually calculated the hours we spent on one other case. This is a different case, but we spent like 620 hours on a case that was going to trial. So, you could spend all that time and all that money, you could just poof and disappear. So it's a big risk. So you want to make sure the case is good and that, you're doing a good job. and that the client is legit. But yeah, but it doesn't cost anything, which is a good thing for the client. And then the Valley says, hello, on the court website, when the lawsuit is filed, am I able to see if the defendant answered or just what my attorney filed? Yeah, you should be able to see the answer as well. Like in New York, at least, you see everything. I think in most places, in federal court, they have, I think, PACER. So in New York, we have like, it's called NYSIF, the New York State Civil Electronic Filing. It's called NYSIF for short, but it's just New York State Civil Electronic Filing. But usually it's a type of electronic filing, or ECF, electronic case filing. Basically, you're going to see everything because, you know, they filed a lawsuit, then the other side files the appearance, the answer. So it's all going to be there. Here's a question. Does seeing a psychiatrist increase settlement? It could, yeah. If you have a psychological claim, like for example, mental anguish or emotional distress, of course you have to see like a psychiatrist or psychologist, because that's the type of doctor that's going to be, you know, giving the diagnosis. If you don't see one and just say, oh, I have mental anguish, but anybody could say that, so it's not enough. You have to have the medical treatment. So it could definitely increase the value. Here's a question from me321Z, and he or she asks, do you see a monetary value difference in needing a total knee replacement because the doc lied that he repaired the tibial plateau fracture properly, and by the time I found out that the bone was too hard to redo the operation, versus the doctor just made a mistake requiring a total knee replacement? The policy is only $1 million. Yeah, I mean, if you need a total knee replacement because the doctor, you know, made this mistake or lied, and you could show that they lied, I think that could be worth more, right? Because that's almost like punitive, where they tried to cover things up and they lied, as opposed to just making like an honest mistake where they could say, look, I'm a doctor, I've done a lot of these surgeries. Sometimes the result just doesn't go the way that you wanted. It's not an exact science. You know, we can't guarantee that every surgery is going to be a perfect outcome. So these things happen. Like medically, it's known that this happens, right? So that's their defense. So if you could show that he lied and he didn't actually repair the tibial plateau properly, and you have expert doctors to testify to that, that could increase the value for sure. I hope this was helpful. Let us know what other questions you have. Let us know what comments you have. We are here for you. Our goal is helping serious injury victims and families. All the best. Bye-bye.